Minister of Justice has proposed many amendments to existing legislation to introduce important reforms in a variety of areas, and he explained the details of what he proposes to do. So, before I start on some of the substantive matters, I would like to digress initially to point out about a controversial issue that has arisen in the Sri Lanka Law College and the conduct of its examinations. Since that subject comes under the Honourable Minister, we have also briefly discussed this in the chamber a few days ago about the new rule that had been promulgated by the Council of Legal Education, asking that the Tamil and Sinhala medium students who follow lectures in English which are conducted at the Sri Lanka Law College to sit for examinations and answer question papers in English. Now, this has created a serious problem for students who are from the vernacular language streams. Now, Honourable Deputy Speaker, both the ministers, Mr. Vijayadasa Rajapaksa, the President's Council, as well as the former Minister Ali Sabri, President's Council, are both vernacular educated prominent lawyers who have been given silk. I have also been a former Minister of Justice. Out of my own experience, I can tell you that even I, when I entered Sri Lanka Law College, opted to sit for some papers in Tamil language, my mother tongue, though I followed lectures in English, because I was more confident in my mother tongue to sit for examinations. Now, this should not be denied to those students who wish to sit for the papers in their own mother tongue. And this, on the pretext of this elitist approach to impose English literacy on the legal fraternity from their law college days, is a very futile exercise, because we must understand that people will have to, over a period of time, develop their ability in English. That is what all of us did. Therefore, I would once again plead with the Minister to reconsider the decision and urge the Council of Legal Education, and I hope what we speak today will be conveyed to His Lordship the Chief Justice as well, as the Chairman of the Council of Legal Education, to consider this matter and give some kind of relief to these students who wish to sit for examination papers in their own mother tongue, since getting or comprehending questions and answering papers is easier for some of those people who come from the rural areas. Because all of us are clear examples for this. My colleague Dilan Pereira too, he is a son of an illustrious lawyer. Still, all of us opted to sit for... there you are. So, several such examples are there. Therefore, once again, I plead that this matter be considered. Now, I don't want to take much of your time, Honourable Deputy Speaker. I would like to refer to one issue here which appears in the Sunday morning, or rather the morning newspaper on Wednesday, November 9th. It says, Supreme Court rejects Muslim women's bid to apply as Qazis. The Supreme Court yesterday refused to grant leave to proceed for two separate fundamental rights petitions filed by a number of Muslim women, challenging the Gazette dated 7th October 2022, which called for applications only from Muslim males to be considered for appointment as Qazis and as members of the Board of Qazis. Now, what is more striking is the petitioners had wanted the said Gazette notification amended to lift the ban imposed on females to apply. Honorable Deputy Speaker, the court did not provide any reason for refusal. Now this issue is a very, very contentious issue where the Supreme Court on several occasions, after having heard counsel in support to grant leave, have refused leave without assigning any reason. Now, for instance, even on when it came to the petitions on the 20th Amendment, variety of counsel appeared for several days. After having heard all counsel, finally, the Supreme Court refused leave without assigning reasons. Now, this is a very, very funny situation. I would like to urge that matters where such important matters, at least brief reasoning must be given by the court to justify why the leave is being refused, particularly when it comes to the original jurisdiction conferred in the Supreme Court. When I say original jurisdiction, fundamental rights as well as constitutional matters, when it comes to the issues concerning the constitutionality of bills before this House, these are matters of original jurisdiction conferred in the Supreme Court. There, the litigants, the applicants, the petitioners don't have a right to appeal beyond that, because Supreme Court is the apex court. Therefore, assigning reasons for the refusal of leave is something that should be normally done, though it is within the powers of the Supreme Court to refuse leave, but not on all peremptory matters, but particularly on important matters, having heard counsel for days on, and they do not assign reasons. And this is a very, very unsatisfactory situation. I would like to urge that these matters be reconsidered. And also, when it comes to the Muslim personal laws, we have asked the Honorable Justice Minister to give us the so-called Sabri Halimdin report, which is still not made public, so that we members of Parliament can examine it and ensure that all these reforms that are necessary for Muslim personal laws would be brought forthwith or without much delay, so that we can have a closure for this problem that exists regarding the controversy on certain reforms for the Muslim personal laws in this country. Thank you.